in India's employment and labor law framework by consolidating and modernizing 29 existing labor laws into 4 comprehensive codes: the Code on Wages, the Industrial Relations Code, and the Code on the Social Security and the Occupational Safety, Health and Working Conditions Code. The government has sought to simplify compliances, improve ease of doing business, strengthen workers' protection, and create a more future-ready workforce ecosystem. Moving to the journey so far, the implementation of the labor codes has been a phased and consultative process. Following the enactment of the codes on 21st of November, the Ministry of Labour and Employment released the draft standard rules for the stakeholders consultation and subsequently issued multiple sets of FAQs to clarify practical and operational aspects of the new framework, including important areas relating to the definition and treatment of wages. The next major milestone was the notification of the central rules under all 4 labor codes on 8th of May 2026, providing the operational framework required for implementation. More recently, significant progress has also been made under the Code on Social Security, with the government notifying the EPF, EPS, EDLI scheme 2026, notified under the Code on Social Security, and wage ceiling of INR 15,000 per month under the EPF provisions, along with the EPF, EPS, and EDLI schemes 2026. These notifications provide greater clarity on the future Social Security framework and are important steps towards operationalizing the provisions of the code. Collectively, these developments reflect the government's sustained efforts to build a modern, transparent, and implementation-ready labor law ecosystems that supports both economic growth and worker welfare. Today, we would like to deliberate on the key impact areas and discuss some practical insights relevant for both the employers and employees in relation to the 4 codes. To help us explore these important themes, we are honored to be joined by the distinguished panel of speakers. Before I call our leadership from IACC Northern Region, let me give a brief introduction about our chief guest for today. That is Dr. Mahendra Kumar, Joint Secretary to the Ministry of Labour and Employment. He's a key member of the core team in implementing the new labor code regime, and because of some prior commitment, he's not here right now, but he will join us at 4 p.m. as committed by him and his team. Now, let me invite the IACC leadership. Let me start with an introduction of Mr. Manoj Singh, who is a distinguished Indian dispute resolution lawyer and the founding partner of S&A law firms, formerly Singh and Associates. He's leading litigation and arbitration expert, specialized in infrastructure-related disputes, and has also served as the special counsel to the multiple government bodies. Mr. Singh has been recently recognized as the Asia Top 30 Litigators by ALB, Thomson Reuters, and recognized by the ET Legal 500 for excellence in arbitration. He's the president for our chamber in the Northern region. Along with him, we have Dr. Lalit Bhasin, who was there last time, and he promised that we should do the series of events, and that's why we are doing this second webinar on Indian-American Chamber with Grant Thornton as a knowledge partner. Dr. Lalit Bhasin is an advocate and the founder of Bhasin and Company Advocates. He's a globally respected leader in corporate law and arbitration. He has served as the past national president of the Indian-American Chamber of Commerce and Bar Association of India and the chairman emeritus of CI Arbitration India. His contributions have been honored with multiple national and international awards, including Lifetime Achievement Recognition and honorary doctorates. I would request both Manoj and Dr. Lalit Bhasin to share their opening remarks to begin today's session on this landmark change which has come over the last decades. Over to you, Mr. Manoj and Dr. Bhasin.
Thank you, Akhil. Thank you very much for organizing this, and thanks to Grant Thornton. So this is a very important legislation which is there in place now. So to start the conversation, distinguished guests, esteemed panelists, colleagues from the legal and business community, and dear members of the Indo-American Chamber of Commerce, a very warm welcome to each one of you. It is my privilege as the North India Regional President of the Indo-American Chamber of Commerce to address you at this GT and IACC webinar on a subject that is both timely and transformative. That is important. So new labor codes, the next phase begins navigating the evolving regulatory landscape. Let me place this reform in context. India labor laws, many tracing their origins to the colonial era, some as far back as 1923, had long been a source of complexity and compliance burden for employers and workers alike. Over 7 decades, a patchwork of 29 central statutes, each with its own definitions, thresholds, and enforcement mechanisms, had rendered the regulatory landscape daunting even for the most diligent of enterprises. Under the leadership of our dynamic Honorable Prime Minister, Shri Narendra Modi ji, the Government of India recognized this structural impediment to economic growth and worker welfare and undertook one of the most ambitious legislative consolidations in our nation's history to subsume these 29 laws into 4 comprehensive labor codes. And why they are important? So these 4 codes are first the Code on Wages 2019, which consolidates 4 central laws on minimum wages, payment of bonus, and equal remuneration. Second, the Industrial Relation Code 2020, which amalgamates 3 laws governing trade unions, standing orders, and industrial dispute. Third, the Code on Social Security 2020, and then the Occupational Safety, Health, and Working Condition Code 2020, which brings together 13 laws on factory safety, contract labor, etc. Now, the most important point, which is most significant, is to me that substantive changes introduced by these codes are significant. For example, the Code on Wages introduced a uniform formula-based definition of wages applicable across all 4 codes, mandating that basic pay, dearness allowance, and retaining allowance must constitute at least 50% of total remuneration, a change that directly impacts the computation of Provident Fund, gratuity, and other statutory benefits. Importantly, it also establishes the concept of a centrally determined floor wage below which no state may fix its minimum wages. So there will be some kind of parity across all the states across the country. Then Industrial Relation Code introduced provisions for fixed term employment with gratuity eligibility after just 1 year of service and raises threshold for prior government approval in cases of retrenchment and closure. Mandates grievance redressal committees in establishment with 20 or more workers and requires a 60-day notice period before any strike. Now, let me turn to the opportunity this reform creates for business. The overreaching objective is to simplify the regulatory framework and balance worker welfare with ease of doing business. For example, a single registration replaces multiple registration under various statutes. Electronic filing replaces the paper-intensive regime of the past. The rationalized definition of wages eliminates a long-standing source of litigation. Fixed-term employment provides project-based hiring flexibility with full benefits parity, and mandatory appointment letters formalize employment relationships across the board. Dear friends, these are not incremental changes. They represent a structural simplification that will materially reduce the compliance burden for enterprises operating at scale, which is a big step to me. For US entities operating in or entering the Indian market, this reform carries particular resonance. The United States is India's largest trading partner with bilateral trade reaching over $200 billion and is the 3rd largest source of cumulative FDI into India at over $81 billion. Both nations have reaffirmed the target of $500 billion in bilateral trade by 2030. Therefore, a predictable modern labor compliance framework is essential to that ambition. For American companies operating through subsidiaries, branch offices, or joint venture across IT, manufacturing, and financial services, the ability to structure compensation, manage workforce flexibility, and ensure social security compliance under a single coherent framework represents a significant reduction in operational risk and cost both. More broadly, in an era of supply chain diversification and geopolitical realignment, India's ability to offer not just competitive labor costs, but also regulatory clarity becomes a decisive differentiator, and these codes, with their emphasis on facilitation over punishment and their expanded social security coverage, including for the gig economy, signal precisely that readiness. So this gig economy or platform economy is going to see a lot of changes or ease of doing business, I would say. This brings me to the role of institutions like ours. Established in 1968, the IACC has for nearly 6 decades served as the apex bilateral chamber synergizing India-US economic engagement. Our mission to promoting trade, investment, technology transfer, and collaboration acquires renewed urgency in this moment of transition. IACC serve as the essential bridge helping American business understand the new compliance landscape, advocating with both governments and facilitating partnership that translate reform into opportunity. Today's webinar is a testament to that role, and there are many experts, including Mr. Akhil, who are going to speak today in an interactive session. As I look ahead, I am genuinely optimistic. Full implementation will require continued center-state engagement, which I'm sure will happen, capacity building in enforcement machinery and sustained industry dialogue. There will be transitional costs like salary, restructuring, payroll upgrades, policy revisions that employers must plan for. But the destination is clear, a framework that is modern, equitable, and globally competitive. One that formalizes employment for millions, extends social security to the gig and platform economy, and creates the condition for India's workforce to be productive, secure, and empowered. I encourage every member, every enterprise, every investor watching today to engage proactively, audit your structures, understand state-specific timelines, seek expert guidance, and position yourself to benefit from what is without exaggeration, the most comprehensive labor reform in India since independence. I look forward to the rich discussion our panelists will bring, and definitely we have Dr. Lalit Bhasin, whose experience keeps on guiding us all the time. He's our flag bearer, torch bearer. So over to Dr. Lalit Bhasin on this note, and thank you very much, Akhil. Thanks.
Thank you, Manojji. And my compliments and greetings, you see, to the leadership of Northern India Council of Indo-American Chamber of Commerce under the stewardship of Mr. Manoj K. Singh, Regional President, and the Secretariat headed by Ms. Kashish Tyagi and Ms. Neelu Sadana. And of course, my compliments to Grant Thornton for partnering with Indo-American Chamber of Commerce in hosting this very important and significant webinar on issues which concern the entire, not only the manufacturing industry, but the services sector, everything which was covered earlier under the labor laws. As Mr. Manoj Singh has rightly said, that the government has taken a brilliant initiative of bringing, you see, rationalizing the laws and bringing 4 codes, putting them in place instead of, you see, this is about 20-25 laws which earlier covered, you see, the labor field. Now, having said that, my suggestion again to Kashish Tyagi and Mr. Akhil Chandana is that we should have a more participative discussion in which we should involve the General Counsel as well as, you see, the law firms who can give their views, because the clients are constantly in touch with them in order to know what are the problems, what are the issues that they are facing. You see, putting the codes in place as well as the rules, that is all right. But one has to ensure that now that it is a law, then the law has to be complied with. And how do we comply with the law? There are certain issues which have come. For instance, you see, what is the role of the state governments? State governments, because there are certain areas in which either there is a scope for overlapping or even the state laws overriding the provisions, you see, particularly in the areas which are covered under the Shops and Establishments Act. You see, the holidays, the working hours, and the overtime wages and everything, you know. So what will be the position? That position is still not very clear. And we have been approached by our clients, UT, to clarify this. Therefore, I'm very happy that Dr. Mahendra Kumar will be there. And I think some clarification would emerge from him. Then there is also the provisions regarding works committee and the grievance redressal committee. Now these provisions were there earlier also, but they were never implemented. You see, under the Industrial Disputes Act, there was already a provision about works committee, about, you see, the uh, grievance committee. Now, of course, a more elaborate mechanism has been put in place, but how this will function, there is no, there is somewhat some vagueness, you see, in this. That if the complaint, which complaints can go to the grievance committee, because it says individual grievances. Now, how do you define individual grievances? If five or six individuals have the same grievance, will it remain, you see, an individual grievance, or it becomes a collective grievance, you see? Therefore, these issues need to be addressed. Similarly, on the issue of wages also, the state governments also have a role to play, as I said, in the working hours also. Therefore, there is a need for some clarity, some FAQs have to be there, which have to be, you see, addressed to the industry on issues particularly concerning the implementation. Because to me, implementation is the most important part. Otherwise, there is a scope for, you see, prosecutions or breach of the law, and which can be avoided by timely clarifications to be issued. But it's a very good step, initial step, I would call it, because it is evolving process. Industrial Disputes Act, you see, was a result of so much of evolution by the judicial precedents. But this is a new law. It may need to be clarified again and again, possibly by the government, by the regulatory bodies under the subordinate legislation, if that does not happen, possibly by the courts. Therefore, I think we should avoid the last option of going to the courts. So let there be a clarification by the government on these issues. I wish the webinar all success. And again, thanks to both NIC of Indo-American Chamber of Commerce and Grant Thornton, Mr. Akhil Chandana. He's been playing a very important role. And please continue to do so. And in the next webinar, please have a more broad-based participation. Thank you.
Thanks, Dr. Lalit Bhasin. We take note of all your recommendations. As you rightly said, we should have more participation and general counsel to be a part of this discussion. As Mr. Singh also said in the beginning, both of you have laid the foundation and expectations of this webinar very high. We'll try to do justice because the kind of panel we have, and I'll go to another panelists who are waiting to get introduced. So we also honored to have with us Mr. Ashish Mohan Vig, who brings decades of leadership experience in India's construction and infrastructure sector. He's currently serving as a member of the Central Board of Trustees (EPFO), and he's also the chairman of the Infrastructure Committee, Indian-American Chamber of Commerce National. His extensive industry experience provides a unique perspective on how organizations are preparing for and adapting to these reforms. And more than this, we have a lot more to discuss with him on the PF changes which have come. So, Mr. Vig, we'll come back to you. Let me introduce other speakers as well. Another very prominent name from industry, Ms. Geeta, Managing Director, India Publicis Resources. Ms. Geeta brings extensive leadership experience in managing large and diverse workforce across industries. If I'm not wrong, more than 28,000 people. Having led people, operations, and transformation initiatives in dynamic business environment, she offers valuable insights into how organizations are approaching the implementation of the new labor codes, balancing compliance requirements with employee experience, operational efficiency, and workforce agility. Thanks for accepting our invitation. Last but certainly not the least, I'm delighted to introduce my colleagues from Grant Thornton Bharat, Mr. Ankur Agarwal and Mr. Sarthak Prashar, who will be deliberating various topics with us today in detail. They are both directors, comes with more than a decade experience, and have been extensively advising clients on this subject. So we are fortunate to have such a distinguished panel comprising policymakers, industry leaders, legal experts, and practitioners. Together, they bring a well-rounded perspective of the rationale behind the reforms, implementation, experience, practical business challenges, and the future of India's labor and employment landscape under the new labor codes. So, moving to the first part of discussion is implementation status, where we are, because as you know, 21st November 2025 is the date when the law got notified. There are a lot of things which have happened in the last 6 months. The government has proactively come out with lot of clarifications, FAQs, central rules got notified. Obviously, the government has taken a 1 year time for the schemes, EPF schemes, EPS schemes to get in place. But I think government has been working very proactively, and they've come out with a scheme which has got notified on 29th of June, which we will discuss in the coming slides. And I think the most important point, which Dr. Lalit Bhasin also pointed out on the state overlapping and all. So while the legislative framework and supporting rules have evolved significantly since the enactment of the labor codes, an equally important aspect is understanding the implementation status across the states, because it's a concurrent law where both central and states government plays a critical role. The pace of implementation has varied across jurisdiction. Let us take a quick look at where things stand today when it comes to the state-wise. As this slide illustrates, while the central government has completed a significant portion of the implementation framework to the notification of central rules and supporting schemes, the state status at a state level continues to evolve. For private organizations, state rules are important for complete implementation of the codes. Otherwise they will not be able to complete this till the time the state rules are getting notified. However, only few states such as Bihar, Gujarat, Andhra Pradesh, and Rajasthan have taken the lead and have notified all or few rules under the new labor codes. However, the final rules from most of the states is still awaited, which slows down the progress of the implementation. So I think as ministry is taking its own time, I will invite Mr. Ashish Mohan Vig. Sir, the same question goes to you. What is your guidance to the industry on the implementation when most of the states are yet to notify the state rules? Mr. Vig, we want to hear from you.
Am I audible?
Yes, loud and clear.
First, evening to and my company for organizing such a beautiful seminar once again. And I'm sure, like Dr. Bhasin said, we get on to such seminars in more frequency with a wider audience and a wider framework. As you have rightly said, there are gaps between the states and the center, and which will affect the industry. Let me give you a small example. Now, the vulnerable section of the workers, I would say, is the unorganized sector, which includes the gig and platform workers. Now, they will tend out on universal protection scheme, which the center is aiming at. So this is a very big dampener. The second will be that the employers who are working in multiple states, they will have a problem because there could be conflicting compliance requirements. Then the seamless portability, which in fact is the very basis of this code, which is digitally based, that there will be seamless portability, that will be again compromised, because if the states do not take on, it will be a problem. So I feel that it is very important that the entire nation, it's something like seamless portability ki main jab baat karta hu, it's something like when you have a fast tag and you move across states, there's no problem. You don't see to encounter any issue anywhere. Now, if every state was going to have their own system, then that won't work. So similarly here, it's a very nice initiative by the center, like you've just heard from the president and from Dr. Lalit Bhasin. It's a very nice initiative by the center, the code, but it has to be universally throughout the nation applicable, followed in full earnest. That is what I feel is important. I just told you three basic pointers which I feel are important, but there are many more, many more.
No, that's very much important, as you rightly said, and I think and we need to make a note of this, and obviously once this relevant people from the ministry join the webinar today, will come back to this question, because this is important to be addressed, and we have to listen from the ministry how the states are progressing and adopting this. Now let me ask Ankur, who's an expert, to take us through key provisions under the different codes on the new labor code, and take us through. Yeah. So Ankur, over to you.
Yeah, thanks, Akhil. Notification of central rules on 8th of May is one of the major milestones in the labor code implementation journey. I'll be discussing on some of the key provisions under such rules. So the central rules for code on wages has prescribed the normal working hours for overtime. When we see the act just mentions that the normal hours for work for overtime will be notified. So it is now notified at 48 hours in the central rules. Similarly, with regard to contract labor, we'll see a lot of changes happening across all the 4 codes. And with regard to code on wages, the liability to pay wages or minimum wages primarily lies with the contractor. But if they fail, then the liability passes on to the principal employer. Another very important change is in terms of payment to contractors for the wages that has to be done by 7th of subsequent month. So this is one area where industry at large has to look into some sort of commercial rearrangements and cash flow impact around such change. Moving ahead with the central rules on code on social security, a very good development happened in terms of the way wages will be calculated for gratuity. So in the old code on social security central rules, there was a rule 34 which provided a different mechanism of calculation of wages for gratuity. It mentioned some of the components such as meal coupon, telephone, and all should be excluded. So on lighter note, understanding and absorbing one wage definition was difficult, and having 2 different wages definition, one for gratuity and one for other components, right, other benefits, was a real industry challenge. So fortunately, in the updated rules, the final rules, the reference what was given in the rule 34 has been removed, and the industry has to just calculate one wages for the purposes of gratuity and other employee benefits. Another very important development, has happened in terms of crèche allowance in lieu of facility. So in the earlier maternity benefit amendment acts and all, the reference was there for a crèche facility to be provided, but it was a real industry challenge wherein because of constraints in terms of space and other administrative challenges, crèche facility was not being provided, or nearby playhouses were not there, crèches were not there, so that tie-ups could have been done. So companies used to give crèche allowance. Now that has been formalized, in the central rules, wherein company can give a crèche facility, can give a crèche allowance in lieu of facility. That is obviously subject to consent of majority of employees. And in terms of gigs and platform workers, the aggregators are basically the market intermediaries who provides the platform and connects buyers and sellers. So they have to register on a designated portal. The portal has been designated. The Samshuvidha portal is live, and they were supposed to register themselves within 45 days of commencement of this rule, which is already, we have crossed the 45 days. If we have audience where you fall under this sector, you have to look into this aspect. And then there is a provision of social security scheme which is yet to be notified, but the central rules provide for the mechanism for the identification of such gig and platform workers for whom such facility or the scheme will be applicable. Moving ahead to the central rules on occupational safety, health and working conditions, the rules have prescribed a standard appointment letter format. So the organizations which fall under central domain, they have to issue the appointment letter in a prescribed format. For protection of women working in the night shift, there is a written consent mechanism which has been introduced. With regard to contract labors, a great development again, wherein a contractor can obtain a single license if they are working in multiple states. Today, the situation is very different. They have to obtain licenses in respective states. Now the contractors are obliged to issue a experience certificate to the workers if there is a request which comes in. There is a mechanism of grievance redressal which has to be provided by principal employer as per the rules, and there is a provision of minimum increment of 2% for the contractual workforce by the contractors. As stated some time back about safety committee, I think by Mr. Basin. So the rules provide for operational mechanism for safety committee in terms of composition, tenure, and roles. And any organization which has 500 or more workers has to look into this compliance aspect. And the last rule on IR code, the worker reskilling fund was introduced in the labor codes, wherein this is an additional requirement along with the retrenchment compensation which was being paid to employees earlier. So now this fund, the operational side of it has been again provided in the rules in terms of operationalization of the entire framework. For grievance redressal committees, which is now required when an organization has 20 or more workers, again operational aspects have been provided in terms of jurisdiction, functioning, composition, and so on. There are extensive provisions for recognition of trade unions. And last but not the least, in terms of standing orders, if an organization has 300 or more workers, they need to have a standing order in place, or they have to adopt the model standing orders. And I would like to add here that the government has proactively already issued the model standing orders for services sector along with some of the other sectors.
Thanks, Ankur. I think you've given a good brief of all the key updates which has been introduced and clarified by way of notifying the central rules. And I must congratulate the ministry to do such a great job in last 6 months in terms of extensive clarification, FAQ, and even notifying the central rules on such a top priority. So now I'm glad to share that we have Dr. Mahendra Kumar, who's the Joint Secretary to the Ministry of Labour and Employment. And as I said, he's one of the key members to the core team. And along with him, we have Dr. Meena, who's the advisor and has been extensively working with the ministry on this subject to share their viewpoint. So Dr. Mahendra and Dr. Meena, the people have been waiting to hear from you. So can you give your perspective before we go into the questions which we have for you to address on each and on different topics in the webinar.
Okay, thank you, Akhil ji. Good evening to all. Good evening to all. Basically, in this type of webinar are very helpful for us also to getting the feedback, what is happening actual, and what are the gaps, how we have to drive the next phase. Now, codes, has been implemented from the 21st November, and the central rules also notified in the 8th May, and after that notifications and other subordinate legislations has been followed, and some are in pipelines also. So most of things are enforced at the central level. Some the rules are left to the state, being labor is in concurrent list. So states also has to frame the rules, and in that progress is also good. Most of state has pre-published their rule. Some have finalized. 4 to 5 states has finalized the rules, notified only, and majority are in the process of finalization. They have done stakeholder consultation, and after stakeholder consultation, There are internal examination from interministerial consultation, legal vetting, etc. And they are also shortly going to notify their rules. That process is continuously we are watching, and they are doing good job. So I hope in a short time we will all the states are on board for these labor codes. Being there is a big change of reform it is, so definitely problems from the employer side are obvious. Teething problems are there, so we are constantly in touch, and today webinar is also will be helpful in that direction. Okay, what are the issues that are emerging now? One thing is very clear: the main thrust of these labor code is facilitator. Inspectors are now facilitators. In addition to inspection, their statutory duty, they are facilitator. For facilitation purpose, lot of statutory provisions has been given. Improvement notice they have to serve before any so-called notice taking legal action. So accordingly, we are doing capacity building of this enforcement machinery. We have taken this work because on papers definitely this facilitator role has come, but this role to keep on ground requires lot of efforts, because everybody is knowing this is mind game, mental setups are there, so it requires change. So on that front we are working, and statutory provision are there. So in a big way we are doing this capacity building workshops and capacity building modules we have prepared, and we are working on that. Just I want to give information regarding this to this house. And regarding these central rules, if some issues are there, then we will clarify through FAQs, and accordingly I think we are also having conferences with employers also for this. So we are taking these in cognizance. And other issue I want to touch regarding this IT platform. We have two portals, Shram Suvidha and Samadhan. On labor codes, this for employers, Shram Suvidha portal is being revamped, and accordingly within a month or so this Shram Suvidha portal will be aligned with the labor codes. That work is also going to be complete. And for this workers grievances, Samadhan work is complete, and this work will also, and at the same time we are onboarding the states also for this IT portal, and there will be a nationalized platform will be there for compliances regarding labor. So that work is also going after implementation of these labor codes, and we are working very fast on this. So those issues just I want to give a light, and now house is open for this any questions, and I want to listen from your side more, because everything has been now implemented and things are coming, and we will our advisor Dr. R.G. Meena is also here, so we will take the questions and discussion we will have.
Thank you. Thank you so
Okay.
much. Yeah, thank you so much, Dr. Mahendra Kumar. Listening to you, looks like that a CEO of a big MNC is giving an update to his people, and the way you've covered, I think, inclusive approach of taking states along with you. You've talked about inspector cum facilitator. which is a very good concept. You talked about capacity building module. You've spoken about IT platforms getting in place. I think a very good insight, and we were appreciating. Everyone was appreciating. We have Dr. Lalit Bhasin, who's the ex-president of the Indian-American Chamber. We have our current president, Mr. Manoj Singh. Everyone was appreciating the kind of work which government at large has done, and the kind of inclusive approach which you have taken. Obviously, on the state, there are some lags. Only Bihar, Gujarat, Andhra Pradesh, and Rajasthan have come out, have taken the lead and have notified all the codes. But you can see the reaction coming from the people at large. I think everyone is so appreciated, and as you rightly said, people have given us a lot of questions before this webinar was introduced. If you remember, this is the third webinar which we are doing, and thanks for accepting our invitation again and again. So while we've discussed about central rules being notified, states are coming with their rules getting notified, and other things, other developments. I think top five industry challenges coming into my mind. The first is on the wages. The second is on the employee versus work analysis. The third is overtime, leave encashment, alternative workforce management. So we'll start with this. Then my first question is on the wages to Dr. Meena, who's an advisor and Mr. and taking this webinar along with Dr. Mahendra Kumar. So we would like to understand on the components which may fall under exclusion of some paid to defray special expenses. As you know that clause E under the exclusion is some paid to defray special expenses. So we want to understand from you what all components can come under that, because I know the ministry has issued FAQs, have given a lot of you know uh, uh, clarification through central rules, but
Yes.
we still want to understand what all components can be fall under this. So, over to you, sir.
Now, I will request Dr. R.G. Meena if he want to say something. I think Dr. R.G. Meena is also on VC.
Yeah.
Meena
Last
ji, yeah.
question to Mr. Meena only.
Good afternoon, sir.
हाँ, गुड आफ्टरनून
सर गुड आफ्टरनून
हाँ मीना जी
सर
आप कुछ बताना चाहेंगे क्वेश्चन लेने से पहले? कुछ समथिंग यू वांट टू से, कुछ क्वेश्चन लेने से पहले बोलना चाहेंगे?
Sure. Yes, sir.
Yes.
See, what we have experienced till now, large number of workshops has taken place by the ministry and the Employers Federation also. But let me tell you, at the grassroots level, still the awareness on the code is not up to the mark. And whenever we are interacting, particularly in person, there is a lot of awareness is required to be generated. And my compliment to the organizers and Chandna ji that you are organizing such workshops. It will be immensely helpful to the industry and the HR professionals and all, but much more is required, because ultimately our manager or the HR officer is going to implement this code, and it is depend on his capacity and efficiency, how successful is the code. Otherwise, as a policymaker, we can talk a lot of things and very good things. And Ankurji has briefed very nicely the rules and all, what are the good provisions are there in that and all. But see, ultimately, we have to reach out. I would request Chandna ji that we should involve the shop floor level management representatives to attend such seminars, and that is going to bring the result to us. So a lot has been discussed on the 4 codes, so I'm not going to touch on the code provisions. Rules has already in public domain. Some doubts are there in the industry if central government has already framed the rules and the state has not framed the rules. Nothing to panic. As per the General Clauses Act, till the new rules are not framed, the rules which are not inconsistent with the code will continue to be operative. So it is not the total, but it doesn't mean that the state will not frame the rules. It is required to be frame the rules, because we have to align. It is beneficial to the workers, it is beneficial to the industry, and there should not have any gap in that. So that is the main point I want to share with you. And then now I'm coming to your questions, because code, we are working very closely with the industry, with the trade union organizations, with the workers representatives and all, but still much is required to be done on that. And now it is required more at the grassroots level or the shop floor level, that how to implement the codes and all. When some other meeting I was there, now there was single
So we're losing you.
registration.
We're losing your network. I think there's a network is a
So
problem.
if any organization is already having registered under the central law, is not required. Okay, can you hear me now?
Yeah. Now we are here.
Yeah. Okay. So
वीडियो बंद कर लीजिए मीना जी, डॉक्टर मीना जी, आप हाँ वीडियो बंद कर लेंगे तो आवाज बैंडविड्थ अच्छी आएगी. Yes,
right.
yes,
Thank you, sir. Thank you. Now you can hear Chandra ji?
Yeah.
Yes, sir. Yeah.
Okay. Thank you. So because I am not in office. So friends, that registration which is already taken by the establishment, he is required only to upload on the portal. He is not required to panic to register again. And establishment having branches more than one state, central government is appropriate government for the PF, ESIC, gratuity and maternity. So registration is taken, then it is the common registration which will be applicable to everywhere. And the license was, Ankurji has mentioned, we have a common license. If any industry want to have a BD rolling at one place, he want to have a manufacturing at one place, and even he want to engage the contact as work as a contractor, then he can have a common license. Similarly, the construction or infrastructure companies are working in multi-states. 8% only small correction is work-based license, even not the state-based. Every work order-based license is required. So, large company like L&T and all, they must be having thousands of licenses. They will get a big relief by this provision once the state government also come on board. So that is the provision we brought it. IR code we have already discussed, but I want to highlight it. The strike now 50% or more workers are concerted leave will amount to strike. That is the amendment we brought it. And the conciliation proceeding in the strike matter will commence only when the first meeting of the conciliation take place by the conciliation officer, which was earlier only receipt of the notice. So that is a change. Thirdly, strike notice is made mandatory for all the industrial establishments. Earlier, it was only for the public utility service. Recognition provision I already discussed, so I am not going to touch on that. OSH, big reform, we brought it a compulsory appointment letter. Friends, it will be a formalization and it will bring a lot of positive energy among the workers that he is having confidence. Yes, I am working with ex-employer and he will have a social recognition in the society. So annual health checkup, today also we have a discussion here when we were meeting with the Karnataka government officials. So facility is extended to the industry to avail from the ESIC. So you please tie up with them, take the time and all, and then fix up it so that there should not be overcrowd before the ESI hospital, and your work should also not suffer. So that industry, you have to guide them. They should make their calendar. They can have internal meetings, and then in the groups they can send the workers who are age of 40 and above for the annual health checkup. So these are the basic points which I was thinking that I should highlight to you. Now coming to the question of wage, we have already discussed it earlier. Also, FAQ has been issued. We have received some more suggestions, so we will be giving more clarifications on the wage, whether the food coupon allowance or in-kind wages, what could be excluded, what could be included. So we will be coming very soon with more FAQs on that. Next to you, Chandra.
No, thank you, sir. I think in last 5 minutes you've given the entire overview and the rationale and the intent of the government behind this entire thing. And even on my question, though you've not specifically mentioned or said anything, but yeah, you've given an indication that more FAQs and more clarity is still coming, and especially the people are waiting for clause E to be captured because it's open-ended. Some pay to defray special expenses. What all should be excluded? Now, my question to Geeta. I know Geeta has been waiting, and thanks for your patience, ma'am. In your experience, has the industry at large been able to successfully implement the revised wage structure? What were the key challenges encountered during implementation?
Thank you and hello everybody. First of all, I want to really appreciate and acknowledge the efforts gone by the Ministry of Labour. This was a very, very positive move, taking us or making us future ready. I know it's a huge challenge and effort, but the industry and business has welcomed it with open arms. I think, as you have seen, we've been collaborating. And thank you, GT and ISS, for having me on this forum, for sharing my perspective on where we are. It's not a very straightforward answer, right, Akhil, in terms of what challenges we are facing. I think different companies are facing different challenges. And from the last 5-10 minutes, what I've heard, a lot of those are going to be addressed with further clarifications that will come out. And for us also as an organization, obviously, the major challenges were that we are a diverse business segment spread across the country, having different structures, approaches, etc. So this code of labor code has actually also pushed us in a direction to review everything at an overall level and not in silos, to see how we can also restructure our compensation in line with the best practices that we want to bring India for going forward as well. But that has been a huge effort, bringing everybody together, because it's not just the internal stakeholders within our organization who have to make the decision. The main concern is on the interpretation. And as rightfully everybody said, there is a labor code that has been shared, then there are state interpretations which are still not very clear. And for us, because we are going to be across the country, we really need some more clarification, and I know for which GT is supporting and helping us, but I'll be looking forward to some more clarifications on some of the interpretations. That's one major thing. Second thing is, making this change is not just, like I said, internal for us to review, but there are different partners that are aligned to make this change. For example, we might involve a payroll partner, we might have a statutory auditor who also looks at this from a financial reporting perspective, each one having their own interpretation on the labor code and how it should be implied. Has been a challenge for us to bring everybody at a unified level, and also to ensure then the systems and technology is talking what we want to implement. So I think that has been one major concern. The other thing is, clarification on certain elements which are very well here, treatment of components such as car lease. I think that this has been, and Akhil would know, this has been a huge contention for us from a financial reporting, statutory audit, whether it's a financial impact, whether it should be treated in a certain way. So we need more clarification around those elements. And also employee versus worker definition for a service providing company like ours, which has again digital marketing, media, IT. How do we define certain roles which are not very clearly articulated today to fall under these categories? I think we'll need some more support, and that's the area where I feel we need to still define further. And obviously from a financial reporting also, how does it get how does the organization get impacted with the overall changes? Because as you would acknowledge, we do not want to impact our employees' take home, right? The structure is changing, but we really do not want to impact the take home. And there are going to be certain provisions and financial impacts on the organization from a gratuity leave encashment. So how do we really treat it appropriately and be within the framework and be compliant is another thing that we are working on. So I hope that helps Akhil and Dr. Mahendra in terms of, at least supporting us and helping us in terms of getting more clarity on the nuances of these areas.
Thank you, Geeta. I think for such a clear, you've laid down all the challenges which are encountered, and just to give a perspective, obviously, as you have a mass workforce and spread out in different states, so you have I can understand from where you're coming, and I think it's a request to Dr. Meena, who just mentioned that we are coming with the clarification and FAQs on what to be included, not to be excluded. Card lease is one angle where we want to understand from you in that, you want to talk about that, sir, right now, or we wait for
one point ma'am has raised, that worker versus
that will
employee.
come. That's the second point. I think we'll come to that. I have a question for that. But before that, if you have any inputs on the car lease, that whether that should be excluded or not, or maybe we are waiting for the clarification, because in none of the FAQ and in the past also we've seen car lease is treated as an exclusion, as some pay to defray special expenses. If you have any view, we are happy to hear you right now, or maybe We are waiting for you to include this as a part of the FAQ, and I'll touch base with you offline on that. Now, my question to Ankur. Ankur, I think you've worked with multiple clients, and we are. What are the practical challenges you have faced with regard to the interpretation of wages? And we wanted to be very quick because we have a lot to cover.
Surely.
The PF as well.
So as Geeta touched upon and Meena sir also touched upon, there are interpretational issues around benefit in kind, remuneration in kind, as well as some pay to defray special expenses. When we talk to auditors, all of them are taking different views. So Meena sir has, I think, kind of given a comfort that further FAQs will come, which will give a lot of comfort to industry. The first two FAQs sir really helped in terms of interpretation. It's a very useful aid for interpretation. Now we are more confident when the wages are being calculated. But some more FAQs are definitely required so that this ambiguity is also taken care of.
Perfect. So now let me go to the another topic, which is again a point of discussion. A lot of deliberation is worker versus employee classification analysis. So, sir, Dr. Meena, my question to you. You've heard Geeta also talking about more clarification. So, is there any expectation that ministry will come out with some guidance or clarification on worker classification? Is there a plan to issue such guidelines in a shorter period of time? Happy to hear from you, sir.
No, thank you. And thank you, Geeta ji. You have taken out the issue of worker versus employee. And let me tell you, I am taking back you to while drafting. So this issue has been deliberated every day. That what is the definition of worker, what is the definition of employee, where the worker should be used, where the employee should be used. But we have, as a policy maker, we have used these terms with the proper understanding. And code on wages, entire code we have used the term employee. And employee means any person who is engaged for unskilled, semi-skilled, skilled, highly skilled, technical, managerial, supervisory work. So wages has to be paid to all the employees in time. Geetaji, IT sector, whether he is getting 2 lakhs rupees per month or 5 lakhs rupees, his wages has to be paid on or before 7th. Earlier, that was the threshold of 24,000. It has been removed. And that was the demand since long. So I want to clarify the August House. You have to make your records accordingly, prepare your IT systems accordingly, that wages are to be paid on or before 7th every month. So code on wage is very clear. Everywhere the term employee is used, and employee means including the IT professionals, engineers, supervisor, managers. Now come to the IR code. Entire IR code we have used the term worker. And worker means definition is clearly defined in the code. Supervisor means actual supervisor. Drawing wages exceeding 18,000 is excluded from the definition of worker. The nomenclature is changed from the workman under the ID Act to the worker. WhatsApp audio. Sorry. So that is very clearly defined under IR code, because IR code is management versus union and all. So that worker is defined clearly under the IR code, and the under IR code, supervisor or managerial exceeding the wages 18,000 is not a worker. But it is not the wages only criteria. There are large number of case laws are available, and industry practitioners are well aware about it. So wages is not the criteria. Even the pilot drawing 5 lakhs rupees per month is a worker. Similarly, if any engineer, IT engineer who is working himself in an organization, whatever may be salary, so he may be worker. So that is clearly defined. So these two codes have no ambiguity about any employee versus worker. Now come to the issue of OSH code. There the term employee is also used and the term worker is also used. To understand simply, as far as the threshold is concerned, we have taken provisions that threshold will be on the worker. If you require factory license, then if you have 20 and more workers, then only you require factory license, not employee. So there your employee definition, supervisor, manager and all are excluded. Similarly, for the threshold of canteen, we have mentioned 100 and more workers, including contract labor. So these kind of thresholds has been prescribed in the OSH code, but again for the providing the facility, the term employee is used. So someone has to study it in depth, or else what I would request you is one separate session should be kept only on OSH code, so that it will clarify whom worker is applicable, whom employee is applicable. Yes. Okay, and then now section 6, appointment letter. So everyone is legally entitled for the appointment letter, because there we have used word employee. And let me tell you, ma'am, while drafting we have a good debate. I witness everything. Because why, if you are working as a manager or GM, why you should not have appointment letter? Because that is the legally proof now. So that gives you the moral support. So we were very clear on that. So appointment letter, then annual health checkup is also for the 40 and above employees, because disease will not come only to the workers, or disease will not come only to the employees. So there the term is used. Section 23 and 24. All the welfare facilities required for the employees, but the threshold is worker. That we have, the mandate is very clear, ma'am. Wherever the facility is required to be extended, so because if drinking water, it is not only for the worker, it is for the employee also. So we were very clear on that. If somebody will read it, it will give a lot of clarity to that. If we are reading from outside, then there will be a अरे कहाँ तो employee लिख दिया, कहाँ worker लिख दिया है, कैसे समझेंगे इसको? Basic concept I am clarifying you. Wherever the threshold is concerned, we have used the word term worker, but wherever the facility is required, we have used the word employee. Now overtime wages we have very calculatively used worker under the OSH code. But overtime provision is also there in the code on wages, but there we have put the rider that the employees for whom many wages have been fixed. So that fine difference one has to understand. Okay, now coming to the Social Security Code, that Social Security Code is beneficial welfare legislation. So commonly use employee word for the EPF, ESIC, gratuity, maternity. Only for the unorganized sector, we have used the word worker. Gig and platform is worker. So there also we have very consciously, while drafting the law, used this term employee and worker, because they are gratuity. If you are working somewhere or I am working somewhere, why I should not get the gratuity? So we all are covered under that definition of employee. Maternity also, every employee. Now maternity benefit is for not only women, but for the all employees. So this also should be highlighted and make aware about the industry.
क्रैच फैसिलिटी मीना जी, क्रैच।
जी सर क्रैच फैसिलिटी की बात कर रहा था। तो क्रैच फैसिलिटी की जो बात है वो 50 एम्प्लॉय पे है। ओके, सो थैंक यू सर, बिकॉज it was debated. Now single parent concept has come. So male can also have child. Where he will keep? So provision has to be made for that. So that has been consciously taken decision, ma'am. So that is because the employee and workers no FAQ is required. It is clearly defined in the law, and it is clearly mandated in the provisions where the facility is to be given to the employee and where the threshold is applicable for the workers part. Okay.
Thanks, Dr. Meena. I think some bit you've given a clarity that in different codes this term has been interchangeably used, so you can gaze, the rationale and can make a clear classification of worker versus employee. But I think what Geeta has asked and industry at large is looking for more clarification. Like you have come out with FAQs, extensive FAQs on the definition of wages. This is one of the topic where industry is looking for a more clarification, and we are happy to conduct a dedicated session for this. And I give you my promise that today also there are almost 1,000 people who've joined this webinar. the more people who are happy to join this and understand this, because this is a bit complicated. Geeta is you are able to make something out of the whatever inputs given by Dr. Meena on the worker versus employee assessment. I just want to hear your thoughts on that.
Yeah, so I think it's a very interesting perspective, Dr. Meena, and thank you for sharing that, right? Because it gives us context of where this has come from. And it's actually, you're right, the confusion is about using worker employee under different codes and interchangeably. Can we use it for a service industry, for others as well, right? So maybe what you have clarified would help us, but it'll be great if we can get some more detailed FAQs around this, because there still is a confusion, and we will go back and read it carefully, like you have suggested, but it'll be really very helpful to get FAQs.
Thanks, Geeta ma'am. Now the next topic, which is again a point of debate and more clarification needed, is overtime. And Dr. Meena, you just touch upon this, but we need more details, as all the employees are now covered under the minimum wages, under the code on wages. Can a view be taken that overtime provisions are equally applicable to employees even if they don't qualify as a worker?
See, don't read to the conclusion so quickly, is the opening remark. The reason is, under the code on wages, minimum wages are not yet fixed. So minimum wages are fixed for which category, who are employees, and all aspect has to be seen. And section 14 is very clear that any employee for whom minimum wages have been fixed, and if he is working beyond the normal working hours, he should pay double the normal rate of wages. So that will take time, let notifications comes, but it is not open to all. Like the managing director who is sitting in the office and says कि 6 बजे के बाद अब मेरा overtime शुरू कर दो.
So that's an interpretation people are taking after reading the law.
That's why I want to tell you. So not to be very specific on that, but let minimum wages notification comes, and if required, we will come out with FAQ on that also, because I am aware about it, because that is concerning to the industries. So, but the code on wages is the employee word is used, but there we have rider is used for whom minimum wages have been fixed. Okay, so but OSH code is very clear, section 27, worker word is used, and worker means worker only.
So what I'm taking a cue from you that overtime should be paid only to the worker, but still the law is, we are waiting for more clarification from your side on the minimum wages and FAQs on this. So moving to another topic, which is again very important, is a leave encashment. So coming to you, can an organization have a leave carry forward balance of more than 30 days of workers, considering the fact that SNE, Shops and Establishment Act, may provide for higher caps still in different, like in NCR. We have 45 as per SNE Act, which is allowed to be carried forward. But I think the central rules and notified, it's only 30 days. So just wanted to check from you how the industry at large should consider this.
See, thank you. This issue and the question has come earlier also. In the rules, we have provided flexibility. One is if you have any practice to provide more leave to be accumulated, it is in the interest of the worker, so it can be continued. That is number one. Number two, there is the Shops and Establishment Act also. So till that provisions are there, it is amended or not. So that threshold is also already there. So that protection is there for the worker also and the employer also. That law has to be complied. Thirdly, if a worker has applied for leave and for any reason he is not granted the leave or sanctioned the leave, then the period which is exceeding to 30 days, he can encash. See, the earlier provision was that only at the time of retirement only he can encash his earned leave. So that is the flexibility given to the worker, that if no doubt that is the provision that he has applied for leave and leave is not granted, then only he will get encashment. But this is the because we were aware about it. And let me tell you, the background, because we have combined 13 laws into one. So some were beneficial. For example, the sales and promotion employees or the working journalists, their accumulation of leave is 90 days and 120 days, because that was already there. So this provision has been deliberated and we have kept it, and then in the code itself also we have provided provisions that flexibility is there. So if any employer want to continue with the more earned leave accumulation, law is not restricting him.
Understood. Understood. So, Geeta, question to you. I think the Labour Code prescribes separate provisions for workers and non-workers in relation to leave encashment. Do you believe maintaining two separate leave policies is feasible, especially in a large organization like yours?
I think it's possible to implement, but it's really going to be a huge challenge to operationalize this, right? Because again, there's a lot of governance, tracking, reporting, and that means additional administrative work for the organization. And I know the Ministry of Labour has been trying to actually reduce all this effort on organizations, which is why they're combining labor codes in one, etc. So if this can be also combined, which will be helpful again for monitoring administration purposes for large organizations like us, like I said, we are different entities, different business segments within the same entity spread across the country. So it will become a huge administrative challenge for us.
Yeah. So Dr. Meena, I think as you heard from Geeta, prescribing different, provisions for workers and non-workers, and that too, state-wise, looking into state rules, whether they are beneficial than the central rules and all. Can't we have a standard policy which can be squarely applicable at our India level without having any ambiguity?
See, I want to clarify you. There is a policy India level, streamline. I want to repeat it again. As far as standing order is concerned, central government only will has power to amend the standing order. Otherwise, universally across country, there will be model standing order will be applicable. Safety standards across country under section 18 of the OSH code, universally central government only will frame for the factory, mines, plantation, and other industries. Regulations also. So we are very clear on that. Now, coming to the specific matter of your accumulation of earned leave, Shops and Establishment Act is a state law, and labor is a concurrent subject. So central government can only advise or give suggestions to the state. It is the state government policy because it is there in their domain. But it is not that, ma'am. We have already identified there were 27, 28 compliances in the Shops and Establishment Act, and out of which more than 20 compliances are already covered under the labor codes. So some 4 or 5 compliances are left out in the Shops and Establishment, which are more specific and pro-labor. So these are the issues. So we have already framed in the regional meetings. We have a detailed discussions with the respective state secretaries and labor commissioners also, and state governments are working on that, either to amend the law or to repeal the law. So it is not that. Yes, sir.
And I just want to add whatever Dr. Meena is saying. We are constantly pursuing with the state to harmonize their Soap and Establishment Act with the labor codes. Definitely, there should be no contravention or conflict of provisions between labor code and Soap and Establishment Act. This is we have agenda in Labor Ministry, and shortly this issue will be sorted out with the states. Many states are coming forward and having harmonized their Soap and Establishment Act according to the labor codes. This we are pursuing this issue. Okay, thank you.
Thank you.
No,
thank you, sir. Thank you for giving that perspective. And obviously, we have seen the ground level functioning of the ministry. It's fantastic. The kind of whatever work has been achieved so far. It's amazing. In 6 months' time, we have seen the progress. And with this, I will shift the gear now. We've discussed about all the codes. We've discussed about the typical issues and everything. Now, I will ask Sarthak Prashar, who's been patiently waiting for his turn. There's a new EPF framework, which, as we said on 29th of June, which is again a surprising, sir. All kudos to the ministry, because the ministry has taken a 1 year period as a transition period, but they've come out with this and notified this, which is amazing. So new EPF framework. Sarthak, over to you to quickly cover. We've left with 15 minutes, and we have some questions by the audience given to us, which we have to ask to Geeta and Mr. Ashish Vig. Over to you, Sarthak.
Sure. Thanks, Akhil. Good evening, everyone. So I think, Akhil, this is more of an evolution of the existing framework rather than a complete overall, I can say. So let me begin with the Provident Fund contributions. So the contribution base is now linked to the definition of wages under the code, while the contribution rates remain unchanged to 12% both by employer and employee, with the prescribed employer share continuing to flow to EPS. There are three practical aspects I can say. First, eventually the wage ceiling. Instead of specifying numerical amount of 15,000, which was there in the erstwhile scheme, the ceiling will now be prescribed under the code. So this eventually allows future revisions through notifications without amending the overall scheme. So employers should monitor the future notifications as well. Second, employees joining above the wage ceiling, the position remains unchanged. PF is not mandatory for the first-time joiners earning above the prescribed wage ceiling unless both employer and employee mutually opt for coverage. Third, contribution on higher wages. This has been a lot of litigated matter in the past few years. Now the scheme expressively permits contributions above the wage ceiling only through mutual consent. Organizations allowing higher PF contributions should appropriate documentation through HR policies or employee declarations. Another important clarification I can say is related to the foreign currency wages. The scheme now prescribes that foreign salary should be converted to INR using the SBI TT buying rate of the last working day of the relevant month, provided much needed consistency for multinational employers. Now, coming to the employee pension scheme, there is no change in the contribution structure. Employers will continue contributing 8.33% subject to the prescribed wage ceiling. However, the scheme now formally incorporates the higher pension framework. Members who exercise the joint option under the erstwhile pension scheme of 1995 continue to contribute the additional 1.16% above the wage ceiling of 15,000, providing statutory clarity to a long litigated issue. Moving to the EDLI, the changes are limited, but I can say those are relevantly important. Contributions are now linked to the code wage definition. Electronic deposit has been made mandatory, further strengthening the digital compliance. Another welcome provision under the EPF scheme is greater flexibility for voluntary contributions. Employees may contribute above the statutory ceiling of 12% or even higher rates, and employers can voluntarily match such contributions. Importantly, neither the employee and the employer are not under any obligation to match the existing contributions. Let me touch upon the withdrawals where meaningful rationalization has been introduced. First, multiple withdrawal provisions have been consolidated into three broad categories, namely essential needs, housing needs, and special circumstances, making the framework much simpler. Second, the scheme introduces a mandatory 25% retirement corpus, ensuring at least 25% of the overall PF balance remains invested. Third, the unemployment provisions have changed. Member can now withdraw up to 70% of their PF balance upon unemployment, while the remaining 25% stays invested. Full withdrawal is permitted only after 12 months of continuous employment, balancing immediate financial support to the member along with the long-term security. Finally, let me briefly cover the one-time three schemes. First, the Employees Enrollment Campaign 2026, which allows employers to enroll all the missing employees from the period 1st April 2009 to 31st March 26, with significant relief where employees' contributions were never deducted. Second, Vishwas 26, that provides reduced rate of damages for settlement of pending historical default cases. Third, Amnesty 26 gives PF private trusts operating without formal exemption a 6-month window to regularize their position. Overall, the government, I can say, has largely preserved the existing framework while introducing greater clarity, simplification, and digital governance, making compliance easier both for employees and employers.
No, thank you. I think so much of changes, and I think it's from an industry perspective, it's not easy. So, Geeta, do you believe these changes require employers to fundamentally revisit their existing PF policies and payroll practices, or are they largely a codification of the current framework?
So I think this is going to be anyways an overall in terms of looking at the labor code and also what things are changing from a peer perspective, right? But I do definitely agree with the sentiment that this is going to simplify a lot of things for our employees. So employee experience from a PF perspective really is going to be very much better, simplified, very clear, and thus that will also help us as employers to ensure that the employees who are existing or have exited, that experience really stays, because for us that's very important. And PF, anything related to it, has been quite a tussle for organizations to manage, especially under exception situations where things are not clear. Withdrawals, loans have become a little cumbersome for our employees, and that I think is a welcome change. For employers, I think for organization, it's a very good step for us to again evaluate, look at the overall assessment of how this impacts from a structure point of view, and whether this could also mean there could be any financial impacts. Again, I'm reiterating to this financial impact that which needs to be covered from an organization perspective, because any such changes and any financial impact creates a lot of challenges from a budgeting point of view, which we have to keep in mind. So that's what we are evaluating. But I think from an overall perspective, not a major change, but a lot of overall of the current framework in line with labor code movement, which is what we are also evaluating holistically at our end.
Thanks, Geeta. Thanks for that feedback, because it's important to hear from you as you have the biggest manpower, and everyone gets impacted. And you rightly said it's before the time, because government has taken 1 year. If they would have come out with these changes after 1 year, then you have to do this exercise again. Right now, it's a time when you have to revamping the structure. You can align a lot of things together instead of revisiting every 6 months or every 1 year down the line. Thank you. Now I'll let come to Mr. Ashish Vig, who sits on the CBT, EPFO board. So, Mr. Vig, as you know, the new scheme largely retains the existing contribution framework while introducing certain reforms. What are the key objectives behind these changes from the government perspective? If you can give us, because you sit on the board, you've gone through these kind of discussions many times, so people want to understand the rational intent behind this.
Yes, thank you so much, Akhil. As we all have been hearing, as we all have been reading, the whole idea of government was, in fact, is to concise and bring it in a very comprehensive way the existing laws. That is why the 4 codes were made. That is why the Social Security Code has been revised and put into action. So that is point number 1. Point number 2 is that there are many facilities which we see now, which is available to the members. Being highly digitalized, it makes the investment or the savings of the member very much safe. You all must be knowing it's a faceless and transparent mechanism now, which is Aadhaar based, highly digitalized, very secure. It also now, as we have been talking earlier, it includes the gig workers, the platform workers from the unorganized sector, which was not there earlier. So it's not just a continuation of the previous one. Another important thing which we must note is that when there is a continuity, then there is no break in membership. One does not have to reapply here. Whatever the savings were, whatever the investments were of the member gets continued. So that is a very big thing, even though the law has changed. The withdrawal facilities, as somebody was speaking earlier, uh, have have become very much better, member friendly. The advances which the member used to get earlier used to take a lot of time. Now it's all computer based. Up to 5 lakh, it's all automated. The provisions against which the advances one used to get earlier, that is housing, education, sickness, it's all been concised. So there are a lot many differences from the previous scheme. It's not just a mere continuation. So I feel it provides greater clarity, encourages voluntary compliance, which is the very basis. In fact, the government has been wanting to bring in this habit of saving for later years, which by and large the workers were not doing. I hope they do now.
Thank you, sir. Thank you for giving the perspective. Sarthak, you left with 5 minutes. I know you have to cover on the international workers and exempted establishments. So quickly, you take 2 minutes and I have a one question for Geeta before we wrap up this today's webinar.
Sure, Akhil. I think let us now discuss with respect to the provisions relating to the international workers. So I can say the new scheme largely relates the existing framework applicable to the IWs as on date as well. Therefore, employers managing expatriate population or cross-border assignments are unlikely to see any major disruption in their existing compliance approach. Here on the screen, you'll see the first point relates to contributions. The schemes continues to recognize the concept of international workers. However, based on the language of the new scheme, it appears that the wage ceiling prescribed under the code may also apply to international workers. Since this is a significant shift from the existing understanding, employers should await further clarification from EPFO. The second point relates to detached workers under the UK Social Security Agreement. From employees who are covered under the Indian UK Social Security Agreement, the scheme specifically provides that PF contributions will continue to be made in India on total wages during the detachment period. Therefore, employers should continue obtaining valid certificate of coverage to claim benefits that are available under the SSA. The another changes on compliance. The scheme introduces a structured monthly reporting framework, and employers are required to electronically report details of international workers joining and leaving during the month. This increases the importance of coordination between HR, payroll, and global mobility teams to ensure timely and accurate reporting. Finally, the withdrawal provisions for IW remains broadly unchanged, and they can withdraw after retirement at the age of 58 years unless an earlier provision is available under the respective social security agreement. So the key takeaway for employers is that there are no major structural changes, and organizations should continue examine and monitor the future EPFO clarifications and strengthen their documentation and processes.
Sarthak, can you cover exempted establishments as well together quickly so that we can, we have one or two questions to ask from Geeta and Mr. Vic, and then before we wrap up, we have a concluding remarks from Dr. Meena. Yeah.
Sure, Akhil. I think for the exempted establishments, the new scheme introduces some of the most significant government reforms, and the government has retained the concept of exempted PF trust. But I think the message is clear that greater flexibility will now be coming up with a greater accountability. The first and most important change is related to the exemption itself. Under the new scheme, the exemption will generally be granted for an initial period of 3 years, after which it will be subject to renewal. Existing exempted establishments have also been provided a transition period to provide to the new framework. Therefore, organizations should not assume that existing exemption will automatically and continue getting review. The second area I can talk about is governance. The scheme strengthens the governance framework by requiring board of trustees to meet at least once every quarter. It also introduces auditor rotation, electronic filing of audit reports, and greater oversight on the functioning of the exempted trust. The third important change relates to the investments in interest declaration. The scheme permits exempted PF trust to declare interest based on the actual earnings of the trust. However, the declared interest cannot exceed the EPFO declared rate interest by more than 200 basis points. The scheme also strengthens employer accountability. Where losses arises due to fraud, misappropriation, or poor investment decisions, employers will be responsible for making good such losses. Further, balances lying in inoperative or non-KYC accounts are required to be transferred to EPFO within the prescribed timelines. Another positive change is the approach towards cancellation of exemption. The scheme provides that cancellation should ordinarily be the last resort. Where deficiencies are identified, employers will generally be given an opportunity to rectify them before exemption is withdrawn. This reflects a more facilitative approach focused on improving compliance rather than imposing immediate penalties. Finally, employers should also evaluate the amnesty scheme. The scheme provides a one-time 6-month opportunity for establishments operating PF trust without formal exemptions from EPFO to regularize their position. Yeah, Akhil.
Thank you. Thanks, Arthur. So my question to Geeta, because you also running an exempted establishment. So from an industry perspective, what is the biggest takeaway for organizations operating exempted PF trust under the new scheme?
So I think, what I'm hearing right now, obviously from a governance point of view, a lot of things are going to change for the better from a transparency. And I think we all already are doing this. Okay, Akhil, running a exempted trust is not easy. As all of us are aware, there are a lot of compliances, governance requirements internally, which organizations have to follow. I think this is going to make more clarity around certain aspects of it, making it also more simpler and digitized, which is a very welcome change. And also certain aspects, like you said, automatic extension of the renewal. That is a significant change, I would say, where again compliance governance will be more strengthened. So not major changes, I would say, but like I said, more simplification, digitization, clarity around certain of these exemptions will have to be taken care by the organizations.
Thanks, Geeta. Thanks for giving a pragmatic approach. So my last question to Mr. Vig. Mr. Vig, as you sit on the board and have a lot more clarity, is the objective is to discourage organization to have the private trust, or by introducing such a strong governance framework? What's the rationale? What a message the EPFO wants to give on the exempted establishments? Mr. Vik, are you there? I think he's dropped out. So we've left with this question. So Dr. Meena, any concluding remarks before we wrap this up? As we're beyond our time of, and I know there are 75 questions which are to be addressed. What we do, we'll respond to each and every question, and along with this, we'll circulate this PPT and our point of view, which we've come out with on the new EPF scheme. People are waiting for. We'll share that as well. But Dr. Meena, anything from your side if you're there on the call still? I think he's also left. So thanks everyone for your patience, for staying with us till the end, and obviously asking so many questions. We've tried to preempt lot many things, and I want to thank our speaker, especially Geeta, who's given a lot of insights and pragmatic way of looking into it as we conclude today's session, and our expert speakers Ankur and Sarthak, and obviously Dr. Lalit Bhasin, Mr. Singh, the ministry, Mr. Vik, everyone, and as we promised, we'll continue to keep this series alive. The more the changes are coming, and we are the first one to come out with our point of view and getting the ministry so that you can hear from them. And looking forward to engage with you. And I would like to thank all the participants as well for joining us today. I think we hope this session has provided valuable insights to help you navigate the labor code implementation journey. Thank you, everyone. Have a wonderful evening ahead, I must say. And as I promised, we'll respond to all the questions. Last but not the least, a big thank you to Indian-American Chamber for giving us this platform and coming with us always together. Thank you.
Thank you. Let's continue these sessions, Akhil. They're very helpful and required with the current landscape, of change that's happening around. So appreciate the team putting this together. Thank you.
Thank you.
Thank you.
Thanks, everyone.
Thank you, everyone.